That's it.
Let's see.
Okay. Now select.
Mm-hmm. No. Let me see the YouTube.
Let's stop. My voice will go there.
I
Yeah.
don't understand why you don't have an option.
Can you confirm whether you can listen to me?
Can you click the join session?
Sorry, what?
Can you click the join session? Jimmy is trying to talk now. You can try to talk.
Yeah. Avi, can you hear me?
Okay, can you try and make me a host or co-host? Can you move me to the panelist area and make me co-host?
No. No, Jimmy need to start. Jimmy need to start.
Avi, we have to start.
唔係個咪啊，
Well, we need the webinar to
我哋整緊 live，
broadcast.
我哋整緊 live， 唔係個咪，我哋整緊 live YouTube。
Just forget YouTube. Just record it. That's it.
Yeah, okay.
You just
Abby, we need to start.
We need to start. Just forget it.
Yeah.
Can start. Just move me to the panelist and make me co-host.
I can't make you co-host.
You can go to participants. Right click on ABHK.
No.
Oh, yes, right there. Promote to panelist. Okay.
Then
Give me a minute. Now just make me co-host.
Make co-host. Yeah.
okay,
All right. Okay.
you can start. He said you can start.
Yeah. So you can hear my voice, right? So have you let everybody in?
Yeah. They are now.
They can hear us?
Yeah.
Okay, very good. So would you like Samuel to speak something? It's okay. Would you like to say something? All right, I think we are already 4 minutes late. Sincere apologies for that. My name is Jagmeet Makkar, and I'm the council member of Hong Kong Institute of Arbitrators. So today's talk is jointly being presented to you, HKIR along with ICS Hong Kong branch. And it's about a very important topic, pitfalls of a poorly drafted dispute resolution clause. Right, it's a very, very important point. And when we want dispute resolution, for that, there has to be an agreement which is part of the contract, and that agreement needs to be in a very good situation. You know, it cannot have an agreement where you're going to have a lot of issues, a lot of pitfalls, then the entire purpose is defeated. So let's very quickly go ahead.
Ronnie. She was
Running, yes, see, this one is working.
I can
Okay,
click here.
fantastic. So just a bit about, it's still not working properly.
How about now? I click for you. I click
Yeah,
for
you're
you.
going to
Yeah,
click
okay.
on it. All right. Okay, let's go back to the first slide and then, yeah, next one. Just very quickly, my background as a presenter. As I said, I'm the council member of the an honorary treasurer of Hong Kong Institute of Arbitrators. So we are presenting this event to you from the office of Hong Kong Institute of Arbitrators. And I'm a member of the Maritime Services Training Board, which is part of the VTC. And there are a few other things. Let's not waste time on that. The next one. All right. So as a practicing arbitrator and accredited mediator, so these are some of the arbitral institutions and associations that I am on the panel of. List, panel, member, advisor depends on various institutions' requirements. So accordingly, I'm part of that. Okay, let's move ahead. Just a disclaimer, if you make a lot of money out of what you have learned today, I'll send you my account number. But in case you're going to use this information, just I would like you to take the responsibility and find out more about that. So Abhi, can you confirm that you can hear me?
He mute.
Yes,
Yeah.
can hear you loud and clear.
Okay, fantastic. So let's move ahead. Yes, Ronnie. Go ahead. Okay. Now this is one of the most important slides, just to give an idea to all the people, the number of contracts which in maritime industry, they come from this relationship. So the basic idea of having ships or shipping is to transport the cargo. And for the ships to be there, you need to build the ships, you can sell and purchase the ships. There are ship management, charterer, operator, port agents. There are a number of relationships there. And in every case, there is a contract. There are a number of contracts which basically come in overhead. So let's quickly look at some of these contractual relationships. Yeah, okay, we just stop here. So you got ship owner and charterer. It's nothing but a contract which you have. We call it charter part. That is something very interesting in our industry, maritime industry is we are very traditional, right? So in the past, when we were calling this contract of carriage as a charter part, we still continue to call it a charter part. It's nothing but just a commercial contract between the parties. All right. And then the cargo which will come from the merchant, either you could be a buyer or you could be a seller, and the sale contract which will be between the buyer and the seller, and that is your merchant. Then they will use the charterers to carry the cargo and you will require a ship. Okay, can you move ahead? Then they will have another set of contracts, seller and buyer with terminal. Can we move ahead? I think, can we get this working?
Let me try.
Well, it's going to be very difficult for me to. All right, let's proceed in the. And let me sit here and do that. In any case, you can't see me, so it's perfectly fine. All right, so one of the most important documents that you will have from the beginning till the end is your bill of lading. One thing we have to remember, you could have a number of contracts in between. You could have the head owner, then you could have the head time charterer, then you could have the time charterer after that, or you could basically have a cargo charterer with whom you have a contract, and ultimately it is the receiver who is going to receive the cargo. We got to remember that it is the ship owner, the carrier, who is going to issue the bill of lading. So there will be a contractual relationship between the head owner and the receiver. Is it working now? Never mind. It's okay. Just leave that. So that would be the relationship over there. So let's just proceed with that. And the different types of charterers that you will have is owner and charter. We already talked about the charter party. You could have bareboat charters, right? Or bareboat come demise till the entire life of the ship. And then you could have time charters. Now, time charters could be period time charters, trip time charters. Trip means from one place to the other. It is not a voyage charter. Please remember, when we say trip charter, it is actually a time charter of a shorter duration. All right. So, and there was a Weher Trave case. Got to be very careful about the trip time charter. If you wanted only one particular trip, you have to say it. Otherwise, it would be in the geographical rotation. The charter can load twice. All right. So, you got to be very careful with that. Then you have the voyage charters. Now, voyage charters could be just a single voyage charter, one particular, you load from here, discharge there, and the story is over. Or they could be consecutive voyage charters. You know, you load the cargo, discharge the cargo, the ship comes back, again loads and goes back. So consecutive voyage charters. Then you got the contract of affreightment. Now this could be volume based or the shipment based. Okay. Now let's take an example of a dispute. Let us say there's a ship called MV Skills Plus Ambition. Charterer is, let us say, the Pastiche Fertilizer Limited, and the owner is Skills Plus Limited, and the contract is, let's say, the amended GenCon 94 voyage charter party. Can anyone tell me what is the latest GenCon charter party? 2022. All right. So 1 second, what is this? Come here. And the contract is GenCon 1994. The voyage, let us say the ship is going to be loading from Jubail. It is loaded from Jubail, Saudi Arabia, and it is going to Santos, Brazil. That is your fertilizer cargo it is carrying. All right. The contractual framework is you have agreed for the lay time and demurrage, 72 hours, Sunday holiday included the total time, and your demurrage is $25,000 per day. And the cargo handling, it is the charterers who are responsible for loading the cargo, discharging the cargo, what we call FIOST. Yeah, it is free of any expense to the owners, and the governing law is English law. Now, what's the dispute resolution clause? We are going to discuss that. All right. So what was the dispute? So the incident did happen at the load port. There were the stevedores which caused damage to the vessel, and the loading was suspended for 12 hours. Discharge port, there was a cargo damage claim of $500,000, and the discharge was delayed by 48 hours. And then there were general average issues. A lot of issues came in. So the owner's claim was almost $700,000 plus cost. And then $150,000 out of that was the demurrage claim, which was for 6 days discharge extra time. That is 25,000 into 6, 150,000. And $50,000, as we discussed, let's say the stevedore damage. And then there was general average contribution from the charterers. So altogether, it was about 700,000 plus cost when we talk about is the lawyer's cost, party's cost. All right. So there could be different resolution paths. Let us say matter goes to High Court. There's a litigation, English High Court, let's say. So what would be the process that would be followed? You'll have to have a claim and defense which will be filed. Then you have case management conference. In courts, you will have extensive disclosure between the parties, witness statements, expert reports, then public trial with cross-examination, then finally you'll have your judgment and the cost order. The key feature is that it is going to be binding, and the court judgment is like a precedent for future cases, all right? It's like the ratio, which is can be referred to for the future cases. Other resolution could be arbitration. So what would be the process here? So what I'm trying to give you is litigation, arbitration, mediation. What is the general process? Just to have an idea. So notice an appointment of arbitrators. Then you need to have written, exchange the written submissions, the claimants, what we call claim submissions. Then you have the defense submissions, etc. Disclosure is quite limited in this case, not like the courts. Private expert tribunal hearing or documents only. In shipping, mainly you will have documents only cases. If you look at statistics, almost like 80 to 83% would be documents only, and few could be through the hearings. All right. Confidential, binding, enforceable award. Now, when we say confidential, it's not given, right? The parties need to agree. You got to be a bit careful about different procedural rules. You need to keep in mind whether your procedure would be confidential or not. So parties need to keep that in mind. So what about the arbitration award? Is it binding on the parties? Yes, it is binding on the parties. But what about the future disputes? No, it's only for, it's got the persuasive power. Yeah, it's not, does not make precedents. So what exactly is arbitration? It's a non-judicial process for the settlement of disputes where an independent third party, which is like an arbitrator, what we call arbitrator, makes a decision which is a binding decision. It's a private and consensual process pursuant to an agreement between two or more parties. Just remember that, to an agreement. So it's important to have an agreement. So that results in a binding resolution of civil and commercial disputes carried out in a fair manner. Now, third one is the mediation. Now, mediation is something which is a lot of focus is being paid nowadays on mediation because it's forward looking and helps in maintaining relationships. All right. So parties, they select a neutral mediator, someone who is not known to the parties. And what will happen is they will exchange their position statements, and mediator is going to create, on the mediation day, the mediator is going to create an environment where the parties. Any luck with that?
Yes.
All right, so I'm back in business now. I can stand and talk. Or
Previous slide.
very good. Okay, let's go to this one. So in case of mediation, what happens is that you got a person, a neutral person. So let's say, for example, both of you are the parties and I am a mediator. So the very first thing I'm going to ask you is, do you know me? You said, we don't know you. Yeah. So basically, I need to be not biased towards anyone. On the mediation day, what I'm going to do is I'm going to, give opportunity. First, of course, I'll give my opening statement and I will put down the whole process that we are going to follow. What I'm going to do, the main thing is I'm going to give you the confidence that I am here, you can trust. You can trust me, and everything which is being discussed here is going to be confidential. All right. And I'm not going to talk to either the parties or to anyone outside. And whatever is discussed here will remain absolutely confidential and without prejudice. So in case the matter goes to arbitration after this, let's say we don't enter into a mediation agreement. So in the arbitration, whatever is discussed here will not be disclosed, or even when the matter goes for litigation. So it is voluntary, good faith, without prejudice settlement. So what is a mediation? Whatever I said just now, let's put it together. It's a process wherein the parties meet with a mutually selected, impartial and neutral person who assists them in the negotiation of their differences. So we focus on the commercial, basically on the interest rather than just the legal rights. So as a commercial guy, I would like to get a result which will help me grow the business. Let us say, for example, I have a relationship with you. I'm doing a lot of charters with you, and on one ship there is a particular problem, one contract. So I do not want that one particular dispute going to spoil my relationship. So through mediation, I can find a sort of win-win situation. So it enables creative solutions which are not available in the court, and it helps preserve the business relationship. So what I normally call this, let's say you're driving a car, and when you look through the windscreen forward, that's your mediation. All right, you're not looking at the side mirrors and always looking behind things which are past. Forget that. Just look forward and then you build the relationship. Then you got some multi-tiered contracts for shipping, especially. You got these two clauses which are very, very important. So you got the BIMCO Law and Arbitration Clause 2020 and the BIMCO Mediation and Alternative Dispute Resolution Clause 2021. All right, so this is very important. What is so special from Hong Kong's perspective? Hong Kong has also been included as one of the options. You've got New York, London, Singapore, and Hong Kong. So parties can choose that as your place of arbitration, seat of arbitration. So here it gives you the option to go in for mediation first. If everything is fine, if the mediation agreement is reached, very good. If not, then you move on to arbitration. So there are plenty of things like med, and things like that we are not discussing today. All right. So why is it that arbitration in shipping, in maritime, is the one which parties like to have the best? So specialized industry expertise. So arbitration panels are composed of maritime law specialists and industry professionals. They decide disputes on commercial merits rather than on legalistic grounds, producing rulings that are commercially sound. So that's why it's always good to have in maritime arbitration the people who are on the panel to have some understanding and knowledge of the maritime industry. Speed, efficiency, flexibility. Again, that's something if you have everything okay with your arbitration clause and there are no issues about jurisdiction of the tribunal, then you can move very, very fast. If you get stuck in that very first point, then this will not work. Then confidentiality, you got to be very careful about it, that you have an understanding and agreement right in the beginning. Neutrality, arbitration offers a neutral forum, avoiding the potential bias of a party's home court. Your forum, my forum, or the neutral forum. All right, so you normally prefer the neutral forum. International enforceability for arbitration. You got your New York Convention, which is extremely important, 1958. You got about 172 member states. What does this mean is that if, let us say, in Hong Kong, I've got an arbitration award, I can enforce that award in a member state of the New York Convention. All right. So that makes it global, as the shipping industry itself is global. So makes it easier for us. Let's say, for example, you're the charterer in Brazil, right? And I'm the owner in Greece, right? And the cargo which is being sold is to China. So we got a number of different jurisdictions which come in. So there could be awards as per the what is agreed under the arbitration clause, the seat of arbitration, let's say, is Hong Kong. So if I'm going to have an award which is issued here, and the assets of the party against whom I have won the award, let us say they are in Brazil. So I should be able to take this award and enforce it, recognize and enforce it in Brazil. All right, so that is the benefit that you get under the New York Convention 1958. Now, this is where it is slightly different from the mediation part. So we do not have Singapore Convention, yes, to a certain extent, but it's not as wide as far as enforcement is concerned as the New York Convention. We just got about 22, I think, states which have ratified Singapore Convention. So between them, yes, the mediation agreement may be.
Convention, New York and Panama one for the whole.
No, New York Convention is for arbitration. The Singapore Convention is for mediation, but still it is not as widely recognized as the New York Convention. The finality and the binding nature of the arbitral awards, that's quite positive. Cost effectiveness, again, it depends. If everything moves easily, fine, there are no issues with your arbitration clause, and it's a clockwork, then yes, cost effectiveness would be there. But if one of the parties does not even respond, so that could be a problematic thing. Yeah. Then party autonomy, we have to remember under the dispute resolution, especially the arbitration and mediation, it is the parties who can decide everything. I can decide what arbitration clause I want. I can decide how many arbitrators. I means we, both the parties together. We can decide how many arbitrators we want. We can decide where we want to do the arbitration. All right. We can decide what procedures, what rules we are going to follow. So that party autonomy is very, very important. So the parties control nearly every aspect. They can choose the arbitrators, deciding the procedural rules, and setting the timeline. So this flexibility is not there in your court procedures. So I talked about New York Convention, so we'll just go ahead. But the enforcement is not to be taken for granted. You've got to be a bit careful about that. All right. So let me give you one example. I think some of the people who are online, I've had a discussion with them earlier also. It could be a problematic thing. You need to really understand. Let us say, for example, I've got an award in Singapore. Now, the party against whom I need to recover the money is in Vietnam. All right. And as we understand, the charter party need not be signed. If everything is agreed between the parties, it's English law, you don't have wet signature charter party. All right. But that charter party is enforceable. And the arbitration agreement is part of that charter party. Now, when I go to Vietnam with that award, it's not 100% sure that the award would be recognized and enforced. Because one of the requirements in Vietnam would be that the signatory of the contracts must be authorized. And that authorization basically comes from either you have a board resolution or you have power of attorney. If you don't have that, in that case, you're going to have issues. So the contract itself may not be recognized, and the arbitration agreement is part of that contract. So that will also not be recognized. So your award may not be enforced. So there are few issues like that. You just need to be careful. So all this is not taken for granted. You need to follow certain procedures. All right. So the key takeaway from whatever we have studied so far, that the arbitration is the cornerstone of dispute resolution for the global shipping sector. It's a combination of specialized expertise, finality, confidentiality, and cross-border enforceability under the New York Convention makes it the only practical choice for an industry that operates across every ocean and legal system. Then what is the problem? All that we have discussed, everything is fine. You got litigation, we don't want it. Arbitration, yeah, we are very happy with it. We can enforce it. Very easy, party autonomy, all that is fine. Then where is the problem? The problem comes here. All right. The arbitration clause, the dispute resolution clause. Now, before we go there, let me just say in shipping what happens. I think Vinod knows that very well. We also call the dispute resolution clause as the champagne clause or the midnight clause. Why do we call it midnight clause? Because during the day, we are negotiating the charter hire, we are negotiating trading exclusions, cargo exclusions, we are talking about delivery, redelivery, etc., etc., etc. And by the time you need to sit and talk about dispute resolution clause, it's already midnight. Then what you do is you just tell the broker as per last, or they just follow what has been followed earlier. So that could be a problem. Something where we should be paying a lot of attention, we don't pay attention. All right. So your agreement to arbitrate, it is the foundation stone of every arbitration. Often parties may incorporate institutional arbitration rules. There must be a valid agreement to arbitrate. Otherwise, recognition and enforcement of the award may be refused if the parties were under some incapacity or the agreement was not valid under its own governing law. All right. So these arbitration agreements are two types. The ones which refer to future disputes, and let's say you don't have an arbitration agreement, you can still, even after the dispute has arisen, parties may agree to enter into a submission agreement. All right. So to refer to the existing disputes. It also establishes the jurisdiction of the arbitral tribunal. It is the only source from which the jurisdiction can come. The arbitration agreement basically provides what is needed to conduct the arbitration. All right, including giving the power to the arbitration tribunal. When we say arbitration tribunal, these are your arbitrators. So parties may draft their own arbitration agreement. Any problems with that? Would you like to draft your own arbitration agreement?
Might miss out something important things, might not have the full knowledge. And miss out important things, so.
But you will generally find all the young boys and girls who are doing chartering. They sometimes like doing that. They have their own homemade clauses, arbitration clauses. So that is something they should be avoiding. All right. So that could be a problem. That's why the word of caution is mentioned here. So often parties will adopt institutional rules as part of the arbitration agreement. Now, it's not really necessary to go in for always institutional arbitration. You can very much have ad hoc arbitration, especially in the maritime industry. Majority of the arbitrations are ad hoc arbitration. All right. So when we talk about institutional, it's like your HPIAC, SIAC, and we talk about the ad hoc arbitration. Ad hoc arbitration basically means like there is nobody trying to administer your whole process. Let's say, for example, Samuel and myself, we think that you are a fit person to be an arbitrator. We both understand your experience and we might decide, okay, let Vinod Sehgal be our arbitrator. So you are the sole arbitrator. So we decide, they don't have to ask anybody to do the appointment. All right. So you got LMA, London Maritime Arbitration Association, Hong Kong Maritime Arbitration Group, SCMA. So these are ad hoc arbitrations. All right, so that's fine. So what are the common problems and the pathological clauses which can lead to ambiguity, and that will then further result in disputes? So these unclear clauses, they will invite challenges, delay, and increased cost. Now, let me ask one thing. What all, if I was to say 4 or 5 things that the arbitration clause should have, what would those be? What would those be? Number one, I need to know the seat of arbitration or place of arbitration. Now, is this seat of arbitration or place of arbitration, is it a geographical seat? What do you think? When we say seat or place of arbitration, is it a geographical seat? You have to sit there and do it? No, it's the juridical seat. So that basically means is that the supervising court of that place would be helping the arbitral tribunal when you meet. Okay? And also the arbitration law that will apply unless the parties have agreed to another arbitration, another law which will apply to the arbitration clause. In that case, the seat or the place is to do with the supervisory court. But let's say I have not separately mentioned the law that will apply to my arbitration clause, then the seat will also take care of the arbitration law of that particular place. Then what else you require? You require which arbitration rules, whether you are going to apply LMA, right? So when we talk about arbitration law, can you think about any arbitration law? English Arbitration Act 1996, Hong Kong Chapter 609.
No,
Right.
it's the 2025 discharge.
Yeah, 2025, but those changes have been made, but still we refer to generally as 1996. All right. So if those things are not very clear, unclear, okay, one more thing, arbitration is mandatory or permissive. Let's say parties may, in case of dispute arising or in relation to, parties may decide for arbitration. Now that may could be a problematic thing. You should try and have something shall. Words like that. Unclear seat, place, or the governing law. Unintended confidentiality. It cannot be assumed. We've got to be a bit careful. Just say if you want it to be private and confidential, you must say that. Finality is not assured by the phrase final and binding. Something else you need to include it, and that is that the appeal waiver, we should try and get that in, should be explicit. Then there could be some impractical processes. Yeah. So 3 arbitrators for a small claim doesn't work much. Unreasonably short deadlines for awards, again, could be problematic. Then some of the pathological part, what is pathological? Fundamentally flawed. So that is called the pathological. So names an arbitrator, specific arbitrator who is unavailable, unwilling, or diseased. The guy is no more there, he's passed away, but his name is there, so and so shall be the arbitrator. Names an appointing authority that no longer exists. So again, something which somehow is not practical. Sets contradictory or impossible qualifications for an arbitrator. Right? So that could be a problem over here. So there are a few more. One of the things which I mentioned is, why should you not have homemade? It's always good to have standardized. So start with the tried and tested clauses. Avoid reinventing the wheels. There is absolutely no point doing that. So it helps to eliminate the ambiguity, and the standard language For example, the LMA clauses, you don't even have to copy and paste everything. Why should we do that? You see, SCMA has got a QR code. You can just put the QR code there. Or by reference, you can incorporate the arbitration clause. It's always good to do that, rather than copying pasting the whole thing. So avoid vague terms and avoid missing the details. Now, these are court tested and enforceable. These clauses have survived judicial scrutiny. High confidence they will hold when challenged. Again, quite an important part. Self-enforcing framework incorporates arbitrator authority, jurisdiction, and emergency relief provisions, all built into the rules that you reference. It's always good to have that, rather than designing your own. Tried and tested in courts, high level of confidence that use of standard clauses is enforceable. Now, clarity is king, ambiguity is the worst enemy, and you don't want to get into that situation. All right. Clear expression to arbitrate must be explicit, not vague. Include confidentiality if desired. Why would you like to have, what's the biggest advantage of having an arbitration as against the court case? Confidentiality. Let's take a practical example. Let's say between my company and other company, let's say I am the ship owner and the other company that's the charterer or the operator. Let's say I've got 16 contracts going. 16 of my ships are with the same person. And I've got all these charter parties running. One of the charter parties, I have a problem. Now, if this matter goes to the court, the whole world will, who will know first?
The
Trade
competitors.
winds. The trade winds will know first. And on the front page, skills plus NAP.
Yeah.
All right. So that itself is going to create a lot of issues, a lot of problems. All right. Not only for the existing business, for the future business, it could be a problem. Arbitral Institution Association. So you just mention, just pick one. Arbitration rules, procedural framework of that institution. It gives a complete procedure, how you're going to do that in terms of appointing of the arbitrators, in terms of your hearings or documents, or disclosures, everything would be there. Seat and place determine the procedural laws, supervising court, and the enforceability. This can decide the outcome. This is some of the very, very important, most important part. Governing law of the contract, law that decides the merits or substance of the dispute. Now, two different things. One is your law of the contract, and the other thing is law of the arbitration agreement or the dispute resolution agreement. Now, these two could be same, but not necessary. You could have two different laws. Okay, let's say English law, which is governing your main contract, which is called the substance or the merit. The arbitration agreement, I may agree to have arbitration in Hong Kong. Yeah, as per the Hong Kong law. All right. So I could have the arbitration agreement, the dispute resolution being done as per the Hong Kong law. All right. But the law which governs my contract, substantive law, is the English law. So just need to understand that they can be two different things. Tribunal composition, very important. Number of arbitrators, qualification, expertise. Now let me just include something here, which is quite an interesting thing. Under English law, English Arbitration Act 1996, let us say, if the number of arbitrators is not mentioned by the parties in the arbitration agreement, then what's the default position? Single arbitrator, sole arbitrator. All right. If the parties agree to appoint the sole arbitrator, fantastic. If they don't, then they have to go to the court. All right. But what about if you agree to LMA 2021 rules? What's the default position? 3 arbitrators. All right. The claimant, they appoint one. The respondent appoints the other one. And these two may appoint the third one. Why may? Why may here? If they have no dispute within disagreement between themselves, these two arbitrators can actually publish, write the award and publish the award.
So minimum is 3.
No, no.
No,
No, in the
LMA default position is
yeah, so that's the
3.
minimum.
Default position, no.
Okay,
If
default is not minimum.
If you and I, as the parties, we can agree to one, perfectly fine. Let's say we don't agree to one, or in the contract, in the arbitration agreement, we don't talk about,
But to do the problem is that if they don't agree, then they will decide to appoint a
Yes.
third
yes,
after they don't agree.
yes. The whole purpose is why you want to waste money. Let's say under the LMA 2021 rules, if you are one of the arbitrators which is appointed by the party, which is called the original arbitrator, I am appointed by the other party, the original arbitrator. Both of us have started on the case and we don't have disagreement. If we don't have disagreement, we can go ahead and appoint the, don't have to appoint the third arbitrator, we can publish the award. However, if there is a disagreement, then we will appoint the third arbitrator. All right? There is another thing. So far, it is documents only, this will apply. But let's say there are 2 arbitrators and a hearing is to take place. Then before the hearing happens, you appoint the deciding arbitrator, third arbitrator. So what I wanted to say, the default position under the English Arbitration Act 1996 is sole arbitrator. Default position under the LMA 2021 is 3 arbitrators. However, only 2 arbitrators if there is no disagreement and documents only procedure can go right up to writing. All right. Language of arbitration, usually the contracts language or key evidence. Again, it's important to mention in the clause. So what was the main point? Clarity. It's all about clarity. Important points, party autonomy, clauses expressing the intention of the parties, subjectivity versus objectivity, and avoid the homemade clauses. And careful drafting is required for the desired effect. Now, getting it right from the start, well-drafted clause, smoother, faster, cheaper arbitration. So all those things like arbitration is cost efficient, arbitration is time efficient, all the positive things about the arbitration, they all start with well-drafted clause without pathological issues cropping up, impossibilities cropping up. Then you can have smoother, faster, and cheaper arbitration. So when you have a solid clause and when you don't. When you have a solid clause, parties know where they are going. Ambiguity, court battles over the clause itself. Where the clause itself, whether the jurisdiction is there. Framework is set, no procedural fights. And if you don't have a proper clause, delays at pre-arbitration, arbitration, and enforcement stages. Arbitration runs smoothly and effectively if you have a solid clause, and if you don't, defeats the very reasons that you chose the arbitration for. Saves time and money, waste both, plus the effort. Right? Does the arbitration clause survive if the contract is breached? Yes. Arbitration clause, actually the dispute resolution clause becomes alive when the main contract is breached. So the example which I normally give is mama kangaroo and the baby kangaroo. Okay, when the mama kangaroo is dead, the baby kangaroo jumps out. So the arbitration clause still is alive even when the main contract is reached, repudiated breach and leads to termination, etc. And minimal interference by courts. This is one cartoon which I love quite a lot. This guy has won the arbitration. This guy has lost. They go running to the judge. And what does the judge say? Gentlemen, you agreed to an arbitration clause with its law, juridical seal, and procedures. You chose your arbitrators, and now you have your award. Better live with it. So generally we find that the courts have minimal interference in the arbitration. Certain things are there. If it is found that arbitrators are biased, natural justice is breached, public policy issues are breached. All right, there is a big issue about the point of law itself, then yes, you may get leave to appeal, otherwise no. All right. So final tips. Use model clauses from leading institutions, LMA, HKMAG, SCMA, HKI, SCSI, etc. Prefer binding word. Shall over the permissive may. All right. Just bring as much clarity as possible in your clause. Prefer wide scope. All disputes arising in connection with over just arising under the performance of. It's always important, arising out of or in connection. Okay. So we got 5-7 minutes. Any questions? Let's see if there are any questions here. Are there any questions?
Not yet. See the chat box? Click.
Do you have any Q&A anywhere? No.
Yeah. I have stopped the Q&A.
Okay.
They can hear you. I can hear you.
All right. If there are no questions, we can continue. We got a little bit time, so I put this as time permitting. All right. Let's look at some of these things, which is if there is no agreement as to the number of arbitrators, which I've already explained. If you're looking at the English Arbitration Act, SOL, if it is LMA 3, all right. Sometimes you find these two lines in the charter party clauses. General average stroke arbitration London. It could be considered as if it means arbitration for GA general average only. So it's important to have clarity rather than just putting words like that.
One question, can you clarify for the audience, general average? I think somebody may.
General average is a very big topic. So for 2 minutes into 1 minute, I cannot. So general average basically means something to do with the insurance. All right, that's average. So if there is, let us say, for example, maritime adventure. Maritime adventure, let's say the ship has sailed out and it has a major issue. Okay? I'm just trying to make it very simple. If there's a major issue, and the master, if he decides, in order to save interest of all the parties, that is a common adventure is there, to save interest of all the parties, he may have to sacrifice. And that sacrifice has to be voluntary. Right? He voluntarily sacrifices, and that loss which happens is then borne by all others, including the guy whose money whose cargo has been thrown, including him. So everybody needs to,
Beyond shares and.
everybody needs to contribute or share in the same proportion as their total interest. All right, so if the ship is mine, then the price of the ship, so I'll have to take average adjustment to call it. All right, so you need to do a proper average adjustment. There are few things that are important. Number one, all the words which I use, maritime adventure, common maritime adventure. Number two, it must be for the interest of all the parties. Third, whatever sacrifice is there, it needs to be done voluntarily. Right? So that's the general average. If against the general average, there's something called particular average. So what is particular average? Now, average again is something to do with the insurance. Particular means it cannot be shared by everybody else. It is for that particular person. All right?
So we
So-
got one question from participant.
Yeah. Sir, what are our options when the opposite party is delaying submissions well beyond the time interval prescribed by the rules of arbitration agreed, and the arbitral tribunal is silent too? It happens in a matter that the claimant's claim submissions did not arrive till 8 months, and while LMA rules mandated 28 days from the date of appointment of arbitrator. It's a very, very important question. It's an excellent question. Now, what you're saying is that arbitral tribunal is quiet and parties agree to apply the LMA 2021 rules. As per that, the claim submission, let's say they have been made, but the respondent has not made any submission. And how long are you going to wait? All right? How long you're going to wait is you need to go back to the tribunal and push the tribunal a bit. Generally, the tribunal will not keep silent for such a long time. I must say that. They will not keep silent. They are going to ask for the time schedule to be followed, because one of the responsibilities. Now let me mention here. The Article 33 of the English Arbitration Act 1996 that puts the general duty on the arbitral tribunal. Number one, that you have to be fair. All right? You cannot be biased. Number two, you need to take steps whereby the cost and the expense is kept minimum. The efficiency is very important. So the arbitral tribunal will keep the general duty, the section 33 of the Arbitration Act. And even like if you're looking at LMA 2021 rules, I think number 3 of the main body of the rules again talks about the same thing. So just to answer this question, the tribunal should be the one who should be pushing for it. If they are not doing it, the tribunal is not following its general duty. All right. So what can you do? That is something you need to send a reminder to them to move ahead of that. Right. But that's the duty of the tribunal.
How do you choose the arbitrators? From a panel of arbitrators or?
See, if it is an ad hoc arbitration, as I mentioned, as the party, you can decide. Let me give you a practical example. Let's say he's got a claim. He's been telling the other party to pay. The other party is not paying, right? Then he decides that he would like to commence the arbitration. So he will come out with the notice to arbitrate or notice of arbitration. So he's going to send the notice of arbitration. I'm not mentioning few more things. What does the arbitration clause say? What are the rules that are going to be applied? What law it is going to be applied? Let us say it is English Arbitration Act 1996 applies. And let us say it is LMA 2021 rules that apply. Let's say. Now, based on that, he is going to send a notice of arbitration, let's say to you. Yeah. Now, when he sends that, he might refer to the para 10 of the LMA 2021 rules. Now, para 10 would be that if you do not appoint your arbitrator, first of all, you need to appoint your arbitrator within 40 days. Let's say you do not appoint your arbitrator within 40 days, then the arbitrator that he has appointed becomes the sole arbitrator, and his decision would be the decision as if
No,
he was appointed
My
by both of
question
you.
was, where do you find this person? Is it from a panel of arbitrators? How do you?
If it
find
is
the-
institutional arbitration, then they will have their own panel of
You
arbitrators,
choose one of them.
not you, that the institution is going to choose, or you can also choose. Let's say you are, your arbitration is, let's say, SCMA. You can actually go to the SCMA website, look at the panel, you can choose. The background will be there, there'll be a CV there, so you might decide what is to be done.
Could be
Alright.
someone you know, and then you would be biased.
I don't think so. Someone you know is fine, but then it has to be disclosed. So we got the IBA conflict rules. So there is a traffic lights. Yeah, you got
He will not
red,
accept.
red, orange, and green.
So he is under obligation not to accept them.
No, he is not under any obligation not to accept. If it is something so very serious, like he is your brother, the arbitrator that, or something like that, in that case, it's so obvious it comes under red. If it is under orange, it means may or may not. So you may accept the appointment, but you make a disclosure that I know this person, he is my batchmate from so and so college, but that was long time ago or whatever it is. See, knowing somebody in shipping, it's a small industry.
Yeah.
Knowing somebody does not immediately disqualify. I know Samuel, so it does not mean that he cannot appoint me as an arbitrator. Of course he can. There's a difference between independent and unbiased. All right. Independent is little bit of a problem in the maritime industry. Because everybody is linked with the other person somehow. Maybe you have met the other guy in a conference.
Yeah.
Or maybe you have known somebody. So it can, independent means absolutely insulated from rest of the world? No, cannot. Yeah. So in the LMA 2021, we don't use the word independent. Oh, okay. So I think we are already past time, so we better stop at that. Any other question? We can take one more question and. Now? That's okay. So with that, I think we will bring today's lecture to an end. Apologies for the initial hiccup. Number of hiccups were there, and apologies for that. Sometimes that unsettles the speaker. The speaker takes little time to get back. Thank you.
Before we end, I'd like to deliver a word of thanks to Jamit for giving this talk. Let's give applause to Jamit. And I want to mention Jamit may deliver further courses in depth about maritime dispute resolution. So this is just a beginner to let everybody have a taste of the issues. And so when that the further courses are coming abroad, then we invite you to join the course conducted by Jamit. Thank you very much.
Thank you, Simon. Thank you so much. Thank you, everyone.
You should, you're mentioning about fighting of the.
Thank you, Jeremy.
Know somebody.
Yeah.
in The trade that you have confidence in. So
Thank
he
you.
knows the business, he knows the disputes, he knows what is demurrage, what is dispatch.
Yeah.
Whether